Hello, everyone. This is a criminal procedure adjudication topic linked to Chapter 7, Part C1 in the Miller and Wright text. We're talking now about jury deliberations. What happens when the jury's deadlocked and they can't reach a verdict? The legal rules and the legal practices in this area try to strike a balance. On the one hand, they try to preserve some space for jury independence and jury deliberation. On the other hand, the law here favors jury unanimity and reaching an agreement rather than getting a hung jury. One of the most visible of these practices is the dynamite charge. As you know, the trial ends with closing arguments from both parties and then instructions from the judge to the jury. And then the jury leaves the courtroom and they go off to their own deliberation room, typically a much uglier room than the courtroom itself, with old discarded or almost discarded furniture, but nobody else is there. Unlike the highly controlled, highly scripted proceedings that we work on during trial, we try to leave these jury deliberations unstructured. The presiding juror, we used to call him the foreman or the foreperson, but now it's the presiding juror, often will act on the judge's recommendation to take an initial straw poll, but they need not. The procedural objective here, what the law is aiming for, is to preserve some space for the juries to think for themselves. This is where we ask for direct popular input into the operation of government in the judicial branch. You talk to lawyers who serve on jurors, and they report, to me anyway, two things. First of all, they say, it's so puzzling. The jurors, it's frustrating. The jurors just give the darndest reasons for the decision they're going to reach. But on the other hand, even though the reasoning is hard to fathom and a little scary sometimes, jurors generally end up getting it right in the view of these lawyers who report back from the land of juries. This New York statute, section 310.30 of the criminal procedure law, gives us a blueprint for what typically happens at trial while the jury deliberates. This is part of preserving the space for juries to deliberate. We really exercise careful control over any contacts with the jury during deliberation. So if the jury's thinking and they say, let's talk to that nice judge again, he or she seemed to be very helpful, they might send a note out to the judge. At that point, the judge has to talk to the jury in the courtroom. You know, the key idea here is that the judge can't just go back into the jury deliberation room and shoot the breeze with the jurors. You've got to bring them back in, put it on the record exactly what the judge is going to say. And the judge is very wary. Lots of judges get overturned on appeal from saying too much, saying the wrong thing to the jury. Now, the jury, once they hear a little bit from the judge, will also want to carry things back with them into the jury room. Sometimes they'll want to bring physical evidence back. Typically, judges will allow that. But they may also want to carry back, printed bits of the testimony or of the jury instructions. There, again, the judges are a little bit more skittish. Their concern is that the appellate court might overturn them because the idea is to keep the jury thinking about the whole case in context, all of the evidence, if the jury asks for one segment of the instructions, well, a lot of instructions are phrased in the nature of on the one hand and on the other hand, and if the jury is asking for the on the other hand part, they might lose sight of the counterbalancing language elsewhere in the instructions. So a bit of reluctance to send particular texts back with the jury. So they get their instructions in the courtroom and then they go back with relatively little in hand to go forward with. Now the jury is sequestered, that is, they are put in that room and they just stay there, at least during working hours, and don't see anybody else. They may be housed in a hotel or something overnight if it's a high visibility kind of case to avoid contamination of the jurors. contact with the outside world while they're supposed to only be deliberating with one another. What happens when they can't reach a verdict, when they get stuck? Our illustrative case here is Commonwealth versus Greer from Pennsylvania. Remember, we have here a call to the Golden Dragon restaurant in Philadelphia asking for delivery. And so the employee there, Ben Zhang, recognizes the phone number, and he says, along with Gomer Pyle of old television fame, "Fool me once, shame on you. Fool me twice, shame on me." He realizes, I've seen this number before. Last time this number called, I was sent out and somebody robbed me. I'm not going to be fooled a second time. So he calls the police and says, I think I'm about to be robbed. The police say, tell you what, go ahead and deliver an empty box to the address where they're calling, where this suspicious call has asked you to go, and we'll be there to catch them. So he arrives at the spot. He's approached by Greer and another man, and they take his cell phone, or at least one of them takes his cell phone. One of the men escapes, remarkable, with the police right there. Jean struggles with Greer. Jean breaks his ankle, but wrestles the man to the ground, and Greer is arrested. Three charges against Greer. There's conspiracy, aggravated assault, and robbery. 2 days of testimony at trial, fairly complicated trial. The jury deliberations begin late on a Thursday afternoon. They only go at it for about an hour before they're dismissed for the day. They come back again the next morning. Pretty early on in the morning, they send a note to the judge, and they want some particular testimony to be read again, and they ask for the judge to give them some further instructions on the law of conspiracy. The lawyers involved in this are always really tuned in to, which part of the testimony the jury wants to hear again. They're trying to get some clue what's going on back in that room. After this morning visit with the judge out in the open courtroom, the jury deliberations begin again at 11 a.m. So an hour and a half later, the jury sends out a note. And they say, we've decided not guilty on the robbery charge, but we can't reach a verdict on the conspiracy and aggravated assault charges. We're divided 10-2 in favor of the conspiracy conviction. We're divided 11-1 in favor of the aggravated assault conviction. Jurors 9 and 10 are the holdouts. So at 1:30, Judge Gary Glaser, who is pictured here, he tells the parties about the note, but he didn't say anything about the breakdown. And so he calls the jury back into the courtroom, and he delivers what's called in Pennsylvania a Spencer charge, which says essentially be true to your convictions, but reconsider your original views. The jury requests that certain testimony be read back, and again they're interested in re-instruction on conspiracy. But after all this, the jury gets back to work by 2:05 p.m. 45 minutes later, new note from the jury. This time at 2:50 it says, our deadlock continues. And this note details the reservations of jurors 9 and 10. It says, they just are not so sure that we've got the actual perp. Apparently they think that the guilty party may be the one that ran away, or who knows, they may have some different theory of the case. They also are especially concerned, 9 and 10 are especially concerned about an apparent mismatch between the account of the police officers who were on the scene and the account of the complaining witness, Zhang. So they, Judge Glaser informs counsel. This time he tells them about the split in the vote, and he suggests that he's going to make one last comment to the jury, that is another dynamite charge. This time the defense objects, but he brings them back in, gives them the new Spencer charge, and sends them back to work. They're back to work by 3:20. He tells them you only have to work until 4 o'clock because it's Friday, and that's as long as this is going to go. But the jury comes back with a verdict at 3:53, not guilty on robbery, just as they said from the beginning, but guilty of conspiracy and guilty of aggravated assault. On appeal to the Pennsylvania Supreme Court, And here we have Chief Justice Ron Castile pictured, the author of the majority opinion. The state Supreme Court upholds the conviction. They talk through different versions of the dynamite charge. There's the federal version, sometimes called an Allen charge, based on its original, the original case that affirmed the use of this kind of charge, Allen versus United States. And in this kind of charge, you can explicitly ask minority jurors, the jurors who were in the smaller group back in the deliberation room, to reconsider their views, and you don't have to say the same thing to the majority jurors. Allen versus United States upheld that charge against a constitutional challenge. Another possibility is the ABA recommendation for an instruction that tries to address all the jurors equally and says each juror has to decide for himself or herself, but all of you should remain open to the views of others. The Pennsylvania law here, embodied in Commonwealth versus Spencer from 1971, condemns two features of the Allen charge. According to the court, the two problems with the Allen charge are that, first of all, it focuses on minority jurors. We're concerned about coercion in this context, and the people who are already getting outvoted back in the jury room are going to come into the courtroom and then get beat over the head by the judge, and according to the Pennsylvania case law, that's just overly coercive. The second problem with the Allen charge, according to the Pennsylvania case law, is that it is pro-conviction. That is, it doesn't talk generically about keeping your mind open, but it talks in particular to the jurors who are interested in acquittal and saying you should keep your mind open for the possibility that this guy really did do it or this defendant really did do it. So a couple of problems, all boiling down to the coercive power of the judge talking to the jurors. So applying this Spencer standard to the instructions given in this case, the two different instructions that the trial judge gave, the Pennsylvania Supreme Court ends up saying, yeah, this is fine. It does not focus in on particular jurors, let's say the minority jurors, and it doesn't push toward conviction rather than acquittal. It's just generic exhortation to keep an open mind while holding on to your own principles. That kind of balance between hold on to your principles but listen to others is a key to upholding these instructions. The concurring opinion has some real reservations about the instructions here, in particular when the trial judge says you're almost there. Well, if you've got an 11-1 vote and a 10-2 vote, what does that mean you're almost there? It does suggest that the 1 and the 2 holdouts are the last people who need to change their minds before you have arrived to that place where you have almost arrived. So seen through the eyes of jurors 9 and 10, you might believe that there was some serious coercion here, but given the rest of the instruction, putting it in context of all the reminders that you have to stand up for your principles, the Pennsylvania Supreme Court says this was not overly coercive, therefore conviction affirmed. There's also some specialized law dealing with the fact that the judge here knew about the division of the vote back in the jury room. Now, if the judge asks and says, so how are you split? Are you, 6-6 or are you 10-2? That could be an error. At least in some states, that's a per se error for the judge to inquire. And actually, under federal law, this is not federal constitutional law, but under the federal supervisory power, the Brassfield versus United States case from 1926 says that if a judge actually inquires about the vote, then that becomes too coercive and it invalidates the jury deliberation. But in this case, again, the Pennsylvania court says the judge didn't ask, the jury volunteered the information, and the judge didn't really refer to that in the instructions in some way that would increase the pressure on the minority jurors. So as long as the judge doesn't deliver the instructions in a way that really focuses attention on the now known split of the jury, the fact that this knowledge is out there or that it's revealed to the parties doesn't invalidate the conviction. Now, does the law have any business at all encouraging jurors to reach an agreement when they're encountering difficulties? Some states think not. I mean, they end up just barring dynamite charges entirely or limiting them, telling judges not to deliver them too early in the deliberations, or maybe not to give it more than one time, or not to give the charge at all unless it was part of the original charge to the jury. So various limitations on dynamite charges out there, reflecting the real concern about coercing the jury when we're trying to get their independent view of the facts. On the other hand, hung juries are expensive. They might result in another trial. Sometimes the prosecution just decides to walk away from the case if there's no conviction the first time, but other times they will retry the case, so it can be expensive. Notice that when a jury hangs and the result is a mistrial, a retrial on those charges is possible and it's not a double jeopardy bar. We just use the legal fiction that the second trial is really just an extension of the first. The first trial was really just suspended and never reached a conclusion, so no double jeopardy bar. Notice, by the way, how much guesswork is involved in building all of this doctrine. We're guessing what's going on back in that jury room, who's going to feel coerced, who's not going to be. We also have a lot of guesswork involved in how jurors react, in fact, to something like a dynamite charge. We do have some experimental studies that conclude that dynamite charges do influence minority jurors to change their views, and that tends to be the jurors who are favoring acquittal. And how often does this happen? Well, we've gotten some studies over the years, and they're listed here on the slide. The interesting thing is there's a lot of variety. In some places it is, more common, a hung jury would be more common than an acquittal. In other places, it's only, say, 2 to 3% in the federal courts of all the jury outcomes. So there's our topic of deadlocked juries. We move on now to other aspects of jury decision making.